A years-long battle between a group of New Jersey fishermen and the federal government landed at the U.S. Supreme Court today. 4 commercial fishing companies who catch herring off the waters of Cape May are fighting a 2020 federal rule requiring them to pay the salaries of federal monitors who watch over their operations and, at times, hop on board to collect data and make sure rules are followed. The court's decision could spill over into other industries, weakening the ability of the federal government to regulate everything from the environment to food safety and even the workplace. As senior correspondent Brenda Flanagan reports, it's among the most consequential cases the justices will decide this year.
A Cape May fishing company is making legal waves before the U.S. Supreme Court over being ordered to pay up to $700 a day for federal monitors. These officials go out with fishing boats to make sure they follow rules and quotas. The company claimed they can't afford it and sued, backed by significant legal firepower from a conservative group who told the justices,
"Commercial fishing is hard. Space on board the vessels is tight and margins are tighter still. Therefore, for my clients, having to carry federal observers on board is a burden, but having to pay their salaries is a crippling blow."
Attorney Paul Clements with the Cause of Action Institute, which argued Congress never intended herring fishermen to pay big bucks for monitors when it passed laws to safeguard fisheries. It seeks not just relief for the fishermen, but also to scrap a long-standing legal doctrine called Chevron, which advises courts to defer to federal agencies when arguments arise over how to best interpret ambiguities in the law. Clement called it inherently political.
And more often, what ambiguity is, I don't have enough votes in Congress to make it clear. So I'm going to leave it ambiguous, and then we'll give it to my friends in the agency, and they'll take it from here.
Clement claimed with new administrations pushing new rules every 4 years, agencies can flip-flop on regulations to suit political objectives. But Solicitor General Elizabeth Prelogar noted Congress can't always foresee every legal question that might arise. That's where Chevron can offer common-sense guidance.
Chevron recognizes is that when Congress hasn't decided it and some follow-on person is going to have to fill in the gap, and it's a question of whether it should be the courts or the agency, there is a presumption here that Congress intended it to be the agency, but always subject to those guardrails about making sure the agency's construction is reasonable.
The Supreme Court hasn't cited Chevron in its decision since 2016, and observers suspect the new conservative majority could seek a major overhaul, if not overturning the doctrine, according to Rutgers law professor Adam Cruz.
I would be shocked to have Chevron overruled outright, especially to the extent of the court saying something like it's never appropriate to give deference to an agency. I think even the Chevron skeptics were acknowledging that it's impossible really to imagine a world where there's not, at the very least, some sort of special consideration or special weight that's given to what the government says.
Overturning Chevron could open legal floodgates, disrupting government regulations on everything from the environment to healthcare, consumer safety, and gun control. It would shift power from federal agencies to the courts and launch thousands of appeals.
There are big reliance interests at stake here because there are dozens, in that case, here thousands of decisions that could stand to be displaced and create chaos if Chevron is overruled.
But the fisherman's attorney argued properly settled cases would remain intact. What's it all mean for the herring fishermen at Bright Enterprises in Cape May? The Supreme Court's expected to rule by early summer. I'm Brenda Flanagan, NJ Spotlight News.